Yes. So basically, as you all know, the term tort, it has been derived from the Latin term tortum, which means to twist. So tort means a conduct which is crooked, unlawful, twisted, or wrongful, rather than an act that is straightforward and lawful. So in English law, we have an equivalent term for tort, that is wrong. So as this branch of law is not codified, that is English law is not codified, even the law of torts are based on judicial decisions. Because in English common law, it is unwritten and uncodified. So basically, we can say that tort is a civil wrong, that is a wrong against an individual. It could be by a breach of a duty imposed by law, and it occurs when somebody deliberately or through any carelessness cause harm to another person, wherein the another party, that is the injured party, can institute civil proceedings against the wrongdoer. He can also claim unliquidated damages. So the basic thing is that, as you all would be knowing, the person who commits the tort, he is called the tortfeasor, and his misdoing, his wrongful act, would be called the tortious act. So in short, we can say that the law of torts is concerned with those particular situations where the conduct of one party becomes a threat or harm to the interest of the other party, the legal interest of another party. So, as we have understood the introduction or basic concept of the tort, I think we have to go to the definition side of tort. So next slide, please. So analyzing the definitions, three of the most important definitions of torts are given by Salmon, Wheelfield, and Fraser. So what Salmon says is that tort is a civil wrong for which the remedy is common law action for unliquidated damages, which is not exclusively the breach of contract or the breach of trust or other merely equitable obligation. So the most important point to be noted over here is that tort is a civil wrong and its remedy is unliquidated damages, and that tort is something which is not exclusively the breach of contract or the breach of trust or any other merely equitable obligation. That is what Salmon says.
Gayatri, sorry to interrupt you. There is an echo when you are talking. Is there some issue with the mic? I'm not sure what's happening.
Okay, let me just check this. Is it okay right now?
Okay. It's still there, but you can continue. If we can't solve the problem, we can continue.
Okay, Chachi. Okay, Chachi. So
Fine,
I will
please continue.
now. Okay. So moving to the next definition, that is of Wingfield. So what Wingfield says is that tortious liability arises from the breach of a duty primarily fixed by law. And this duty is towards persons generally, and its breach is repressible by an action for unliquidated damages. That is what Wingfield says. Now, moving on to Fraser's definition, he says that a tort is an infringement of right of a private individual giving a right of compensation at the suit of the injured party. So, from all these three definitions, the points we have to understand is that tort is a civil wrong. For it, the action in common law is that of unliquidated damages, and it will be available to the injured party whenever the wrong is committed against him by the tortfeasor. And tort should be something which is not merely the breach of contract, the breach of trust, or merely any breach of equitable obligation. Now, for any act, there are certain essentials, there are certain ingredients required to call something the name it has. So, moving ahead to the essentials of tort. Next slide. There are two important essentials of tort, that is an act or omission and legal damage. So only when there is an act or omission and a legal damage, we can say that the tort is constituted. So what is an act or omission? So to make a person liable in tort, it is very required that he must have committed some act or omissions in the performance of his legal duty. For example, if somebody is entering someone's property without any lawful justification, or somebody is defaming a person's reputation, there results an act of trespass or defamation. So similarly, the point is that you should be doing something which you are not supposed to do, and you should have omitted to do something which you are supposed to do. So malfeasance and misfeasance, that is that. And coming to the second point, that is legal damage, it's important that to be successful in an action for tort, the plaintiff has to prove legal damage or injury on his part. So unless there is a violation of legal right, you cannot bring an action under the law of torts and you will not succeed. So these are the two essentials of torts, that is act or omission and legal damage. Now, next slide. The major question which we have to address when we learn tort is that, is it the law of tort or is it the law of torts? So in this connection, Salmon has said that it is the law of torts. So he says that no law of tort is there, but there is law of torts. So the simple thing that I do to keep this in mind is that Salmon starts with S. So just keep in mind that torts is a plural form and Salmon's name starts with S. So just remember, it is Salmon who said that it is law of torts. And coming to Winfield, he is of the opinion that it is law of tort. So according to Winfield's theory, he says that if I injure my neighbor can sue me in tort whether the wrong happens to have a particular name like assault, battery, deceit, slander, or whether it has some special title at all. Still, I shall be liable if I cannot prove lawful justification. That is what Winfield says, and that is why he says that it is the law of tort. But Salmon, on the other hand, he preferred the second alternative for him. Because for him, he is telling that there is no law of tort, but there is law of torts. So this means that the liability under this branch of law arises only when the wrong is covered by one or other of the nominate torts. So there is no general liability, general principle of liability, and if the plaintiff can place his wrong in any one of the pigeonholes which contains a liable tort, he will succeed. That is what Salmon says, and hence we know that this theory has a name also, that is pigeonhole theory. So just keep in mind that it's Winfield who thought about law of tort, and it's Salmon who says that it's not law of tort, but it is law of torts. Now just moving on to the next slide. Now, the nature of tort. As we have discussed, tort is a civil wrong. That is, the basic nature of a civil wrong, as you know, is very different from criminal law. So in the case of a civil wrong, the insured party, that is the plaintiff, he initiates civil proceedings against the wrongdoer, that is the defendant. But in case of a criminal wrong, on the other hand, criminal proceedings are instituted against the accused by the state. Also, in case of criminal wrong, the individual who is a victim of the crime, that is the sufferer, he is not compensated. But justice is administered by punishing the wrongdoer in criminal cases. But coming to the civil side, the wrongdoer is punished by way of imposing some kind of penalty like compensation. The sufferer is compensated monetarily when it comes to civil side. Sometimes it is possible that same and done by a person may result in two wrongs, that is a crime as well as a tort at the same time. So in such a case, both the civil and criminal remedies would concurrently be available. So there would be civil action requiring the defendant to pay compensation as well as criminal action awarding punishment to the wrongdoer. Now the second ingredient is the nature of tort is that tort is other than a mere breach of contract or a breach of trust. So as we know, tort is that civil wrong which is not exclusively any other kind of civil wrong. So if we find that only wrong is a mere breach of contract or a mere breach of trust, then obviously it will not be considered to be a tort. So this is a person agrees to purchase a set of radio that does not fulfill his obligation if the wrong is a mere breach of contract. So it is only the process of elimination that we can find whether the wrong is a civil wrong or a criminal wrong. The third point is that the nature of tort is redressable by an action for unliquidated damages. Am I audible?
Yes, Gayatri, you're audible. Please continue.
Okay. So the third point is tort is reducible by an action for unliquidated damages. So damages in the case of torts are always unliquidated, which means that it would be at the discretion of the court to decide the amount to be compensated. So this is because, as in the case, unlike in the case of contracts, parties are not known to each other unless the wrong is committed. So therefore, when a problem arises, it will be up to the courts to determine the quantum of compensation to be awarded to the parties. And that is why we say that in tort, the damages are always unliquidated. Now moving to the next slide. The difference between tort and crime. So as you know, tort is an infringement of a private or civil right. And therefore it is considered to be a wrong against a person to whom the damage has been caused. But on the other hand, when you analyze crime, it is a public wrong. So in tort, the injured party usually brings an action against the wrongdoer. But coming to the criminal law, the wrongdoer is prosecuted by the state even though the victim is in the state. The victim is an individual, but still it would be the state which institutes the proceedings against the wrongdoer. Again, in the case of tort, ends of justice are met by awarding compensation to the injured party. But in the case of criminal law or a criminal wrong, ends of justice are met by punishing the wrongdoer. So this is what some of the basic difference between tort and crime. Now coming to the next slide, that is difference between tort and contract. Yes. So a breach of contract results from the breach of a duty which are undertaken by the parties themselves. So the agreement, that is a violation of which is known as a breach of contract, is made by the parties with their free consent. So the parties are putting forth some agreements. When they violate it, there results a breach of contract. But on the other hand, coming to tort, the breach of a tort results when the duties imposed by law are violated by the parties. So we can say that a tort results from the breach of such duties which are not undertaken by the parties themselves but which are imposed by law. The next point is that in case of contract, the duty is based on privity of contract and each party has owes a duty only to the other contracting party. But on the other hand, coming to the law of torts, duties imposed by law under the law of tort are not towards any specific individual, but they are towards the world at large. So one point we have to note is that even in tort, only that individual will be entitled to sue who suffers damage by the breach of duty. So this is the only similarity we can point out when it comes to tort and contract. That even just like in the case of a breach of tort, even in the case of breach of contract, only that individual will be entitled to sue who suffers damage by breach of the duty. The next point is that with regard to damages. So damages is the main remedy available in case of both breach of contract as well as breach of tort. So in case of breach of contract, damages may be liquidated because parties know each other, so they would be putting forth agreements and terms defining the amount to be compensated in case there arises a breach of contract. So another difference between breach of contract and breach of tort is that in case of breach of contract, damages will be liquidated, whereas in an action for tort, they are always unliquidated. Now coming to the next slide, that is the general principles of tortious liability. So speaking about the general principles of tortious liability, the first and foremost principle we have to understand is that principle of injuria sine damnum, that is injury without damage. So what injuria sine damnum means is that legal injury without any actual harm, loss or damage. So this maxim means that when a legal injury is caused to a person, it is actionable even though there is no damage caused to the person as a result of such injury. So the main object of the law of tort is to protect harm being caused to the property, body or reputation of a person. So an action for damages in this case, an action for damages lies for infringement of an individual's legal right. So injuria means violation of legal right and sine means without damnum means damages in the form of money, health, and reputation. So thus, injurious sign damage means violation of legal right without any damage to the plaintiff. So we have certain important case laws in this context, that is Ashby versus White. That is a 1703 case. So in this case, the plaintiff was a voter in a parliamentary election. But what happened is that when he was about to cast his vote, the defendant wrongfully refused to accept his vote. But anyway, the candidate to whom the plaintiff wanted to cast his vote in the election, he won the election having a clear majority. But still, the court awarded around £5 to the plaintiff on the ground that there was a violation of the plaintiff's legal right to cast vote. The second case is that of Williamson versus State of J&K, that is a 1968 case. So in this case, the petitioner, that is an MLA of the state of Jammu and Kashmir Assembly, he was wrongfully detained by the police while he was going to attend the assembly session. Also, he was not produced before the magistrate within 24 hours as was required by the law. So as a consequence, this person, he was deprived of his constitutional right to attend the assembly session and fundamental right to be produced before the magistrate within 24 hours. So the court looked into the matter and the Supreme Court awarded to him around 50,000 rupees as compensation by way of consequential relief. So where there is injury, that is infringement of right, plaintiff is entitled to damages and compensation even though the plaintiff has not actually suffered any material loss or damage. The next case is that of Constantine versus Imperial London Hotel. That's a 1944 case. So in this case, the plaintiff was a West Indian cricketer and he reserved a room in the defendant's hotel. So they could not provide the room demanded by the defendant and they arranged another room in another hotel. So the court held that even in this case, the plaintiff has, even though he has suffered no damage, but there was a legal violation. So therefore, the plaintiff was allowed to recover nominal damages from the defendant. Because he has a right to stay in the hotel in which he has ordered. So if he couldn't be accommodated there, then he is entitled to nominal damages. That is what the court held. Next case is that of Ljrf versus Municipal Corporation of Agra. So in this case, the fact is that the plaintiff's name, it was deleted and dropped from the voters list by the concerned election officials, due to which the plaintiff was not able to exercise his right to vote. So the plaintiff sued the Municipal Corporation of Agra for the violation of his fundamental right, and the court held that the Municipal Corporation of Agra is liable because the plaintiff's legal right to vote was violated, and hence compensation was granted to the plaintiff. So precisely telling about injurious sign damage, it says about compensating the plaintiff whenever there is a legal injury caused to him, even though he does not suffer a material loss or actual damage. Second principle of tortious liability is damnum sine injuria, that is damage without injury. So in some cases, a person may suffer actual or material damage, but there may not be a legal right violated on his side. So in this case, there is a damage, but there is no legal injury. It means damage without breach of a legal right will not constitute a tort, and such a violation is not actionable in the court of law. So damnum means damage in the form of money, comfort, health, etc. And injuria means violation of legal right. Sign means without. So every person has a right to carry on his trade or profession in competition with other, even though this competition may cause loss to his rival. So the question is, if I suffer a loss as a result of my competitor's action, can I sue him if he is not violating my legal right, but he is causing me an actual damage? So we have a famous case of Gloucester Grammar School's case, that is a 1410 case, which clearly speaks about this. So in this case, plaintiff was running a school and the defendant had also set up a new school nearby the plaintiff's school. And the plaintiff, he was forced to reduce the tuition fees for obtaining children from substantial margin, since children of the plaintiff schools were trying to join the defendant's school. So the plaintiff held that he had no right to complain the opening of the new school. I mean, the defendant opened the new news code. So the plaintiff complained to the court that the defendant cannot do that because he is affecting his right to, that is, a plaintiff's right to carry on his trading profession. But the court held that the plaintiff had no right to complain the opening of the news code by the defendant. And the court also held that there is no damage, that is, there is no legal damage and there is only actual damage. So there is no legal violation of any legal right on part of the defendant as against the plaintiff, and hence this is a fit case of damning sign injuria and no action will lie. That is what Gloucester Grammar School case upheld. Similarly, in Ushabas versus Bhagyalakshmi Chitramanda, that's a 1978 case. In this case too, the plaintiff filed a suit for permanent injunction against the defendant in order to restrain them from prohibiting from showing a film called Jai Santoshima, because it is held that it hurts religious feelings. So the court held that since there is no violation of legal right of the plaintiff, he cannot be entitled to take any legal remedies in this regard. The third case is that of Mughal Steamship Company versus Mcgregor Government Company. So in this case, a number of companies trading in steamships, they combined their hands with the intention to draw the plaintiff's company out of the tea carrying company. They did it by reducing and offering assistance at a reduced price than the plaintiff's company. So the plaintiff was aggrieved by this and he approached the court, but it was held that plaintiff has no cause of action as no legal right has been infringed by the other company. Even though there is an actual damage caused to the plaintiff, there is no violation of legal right and hence no action would lie. That is what was held in this case. Similarly, the last case, that is Nair of Bradford versus Pickles, that's an 1895 case. So what happened in this case was that the corporation of Bradford, it was supplying water from its wells, and the defendant was having adjacent land to the corporation wherein there was the well. So the defendant was willing to sell his land and he approached the mayor of the corporation, but unfortunately all negotiations failed. So what the defendant did was that he dug a well in his own land by cutting the water underwater ground supply by the corporation well, so that the corporation will not have adequate supply of water, because when the land is uneven, the land that is lying at a lower level will be having, the water will be flowing to that area. So the plaintiff, he sued for damages for malice. But what the court held is that the defendant is not liable because the defendant's act is not wrongful, because it did not violate any legal right to the plaintiff. He's digging a deeper well in his own land, even though with actual malice. But as it is not violating any legal right, even though there is an actual damage, there will not be any action lying against the defendant. That was what the court held. So these are the two principles that we have discussed in the previous class regarding the general principles of tortious liability. And that's all for today's review class. Thank you.